Muted. Muted again.
Okay, I am muted. Hey, here, here I am. Let me say what I just said so that you hear it. Stick to your review sheet. That's the important thing. Make sure in this crazy time of year with all these other classes and all these other things due that you focus on, for my class, the review sheet. I think that there are a, just there's just this one chapter to read, right? And yet there are an awful lot of review terms, and so you need to pay attention to those. They're legal terms, and no, they're not used too often in regular conversation, but they are important for you to know. Uh, yeah, the worksheet, whatever you want to call it, the study guide, the worksheet, key terms, that annoying thing that I give you that tells you what's going to be on the test. And that's important for you to pay attention to. There are Supreme Court cases, and those are important ones. They're on there for a reason, because that's what, folks know about the Supreme Court and things that'll come up in conversation. But Google's your friend, and make sure that you Google stuff. Yeah, make your notes from the worksheets, and the most important thing you can do is move beyond just defining them. What's significant about the term? Why should you know something about uh, Roe v. Wade? Yeah, use Google. That's what it's there for. And it will give you news items, perhaps, if you click over there on Google News, about current things about those cases. And there's stuff in the news all the time about legal issues, and so you should at least have a passing understanding of legal concepts. It's been fun. I have not watched one moment of the Johnny Depp, uh, what's her name, Miss Heard's trial. It's my understanding that Depp is suing her, Amber Heard, suing her for defamation. And so what is he saying? He's saying that the allegations that she made about him have defamed him or damaged his reputation, or in a tangible way caused him to be sort of box office poison, as we used to say, where he has been unable to work. Studios won't hire him, people won't hire him, projects, tangible things. He's lost income. He can show a harm regarding the statements that she made. And because he's a public figure, it's a little harder for him to win these cases, this case. Why? Because he's held to, yeah, Disney fired him. Um, Actors have been fired, and so they fired him because, look, they don't. It's not that they're taking a big position against abuse. It's Disney. Disney's about abuse. They're always killing off some poor creature's mother in these films, like Bambi or Dumbo or whatever. It's not that they're against abuse. It's that they couldn't make any money. They didn't think anybody would go see a movie with Johnny Depp if he's got a reputation as an abuser. So he's going to show that, and he's going to say, she said I abused her and I got fired because of it, and she knows I didn't abuse her, and other people will testify that I did not abuse her. And he's got to prove that she knew the statement was false but made the statement anyway. That's actual malice. If a newspaper prints allegations that they know are not true, but they print them anyway with reckless disregard for the truth, that's actual malice. And he can prevail in this suit. And so some people have been laughing about, well, it's the only time they've ever understood hearsay. Lawyers are probably laughing about this. Depp evidently defined hearsay for people in the court, and some law graduates, law students, lawyer types that I know have said, well, he knew it better than anybody else in the courtroom. What that mean, what hearsay in court is, and in this case, you'll hear idiots say, this is a he said, she said kind of thing. Well, if she's lying, and he can prove that, because that's his assertion, he's got to prove it. He's got to prove that she lied with actual malice, that she knew the story wasn't true, but she printed it anyway. What is hearsay? And you hear this a bunch. You can't say that in court because it's hearsay. Hearsay is a statement that's offered for the truth of the matter asserted. Now, a statement is offered for the truth of the matter asserted. There are about 17 exceptions to hearsay, and the exception makes the rule. So a person cannot just simply say, an out of court statement made for the truth of the matter asserted. So if it's not made, and here's a good way of remembering this. If it's not made and subject to cross-examination, it's not admissible in court. So out-of-court statements are not admissible in court unless they're part of the exception. And there are all kinds of hard and fast exceptions that people cannot be compelled to testify about. The most famous is, let's say a murderer commits a murder, runs into a church, says, hey, priest, come here and hear my confession. And in that confessional, he says, I killed this guy. The police come in and they question the priest and they say, did he tell you that he killed this guy? And the priest says, I'm sorry, I can't testify to that. The sanctity of the confession. You cannot compel me to testify to what he said in confession. That's true. That's true. And there's no exception for that. A priest cannot be compelled to testify. A lawyer normally cannot be compelled to testify about what a client told them in confidence, unless, y'all, it is in furtherance of a continuing criminal act. So a lawyer can't lie about what their client said. It's perjury. But if it's covered by attorney-client privilege, they can't testify to that unless it's in furtherance of an ongoing criminal conspiracy. Right? A doctor, particularly a psychiatrist, cannot be compelled to testify about what a patient told them in confidence, unless to withhold that information is dangerous to a client. So if somebody goes in and says, I can't take it anymore, I'm going to kill my wife, the psychiatrist has a duty to warn the potential victim of their patient's intentions. But like a crime that's already been committed, the psychiatrist or the doctor cannot be compelled to testify about that. So Depp evidently said, and I didn't see it, I'm not watching that stuff. It's not that compelling of a trial. If Depp told them what the definition of hearsay was, that a statement, an out of court statement offered for the truth of the matter asserted. That's hearsay. There are some exceptions to it, like an excited utterance. Somebody has a car wreck and jumps out of the car and says, "Man, I'm drunk and I didn't see the stop sign when I hit you." That is admissible. That's called an excited utterance, and it's an exception to the hearsay rule, and it's available for court. But most of the time, y'all, look at it this way. If somebody is not subject to cross-examination about what they witnessed or what they heard or what they might have said or what somebody told them, then that's not admissible at trial. That's not admissible. Okay? All right. So I'm going to take a look at this little study guide and go through the little study guide with you and see if there are things that just leap out that might be good for us to talk about. All right. The material about the federal courts is really pretty simple, and the little booklet, Understanding the Federal Courts, is amazing. It is really outstanding, and I recommend that you look at that PDF, because it will help you understand what happens and what you should know, what anybody should know about the federal courts. It's not lawyer material. It's produced by the feds to help everybody understand what happens in the federal courts. So it's really very very well done. And if you look at the lecture notes on the federal courts, civil liberties and civil rights, that's really good stuff for you to understand what's happening. The lecture notes are really good and very, very helpful. But if you look at that worksheet, there may be concepts on here that may be difficult for you to find or not really understand. By the way, it's in alphabetical order. It's not in the order that it appears in the text. So you should feel free to ask questions about it. And what should you know in terms of these Supreme Court cases, right? Because, oh my gosh, they're so overwhelming, and the discussions about them are really lengthy. And so, what should you know? Simple. If you will go, and I will put this in the if I'll put this in the little chat here for you to see. Wait a minute, my desk drawer's closed. Let me fix this. One of the knobs wants to come off, and I don't want to pull on it too hard. Okay, yeah. The best website about the Supreme Court is a website called oyez.org. And I'm going to go to that website and let's see if it will let us share it so that you can use it, because I like it, and it is done by the Supreme Court itself, and it's super good. Yeah, it's from Cornell's Legal Institute. I'm sorry, I misspoke. And Cornell has a wonderful legal information center that really gives you a tremendous understanding of the Supreme Court. And they give you some marvelous websites that can help you a great deal. And this is like people's full-time job to manage this website. I know you think, what in the world is Oyez? oyez.org. It's pronounced Oyez. And this is the word that's used at the beginning of every Supreme Court session, and I'm going to play the audio for you. And let me turn up the sound so you can hear it. This is the beginning of the Supreme Court. This is what they say.
The Honorable, the Chief Justice and the Associate Justices of the Supreme Court of the United States. Oh, yay, oh, yay, oh, yay. All persons having business before the Honorable, the Supreme Court of the United States are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court.
So that's the beginning of a Supreme Court session. And let me see if I can share. Let's see. I may have to open that in another window. That might be the best way to do that. oyay.org. And let's see what it tells us here about sharing. Okay. Share screen. And you pull this little window down right there. Oh, yay. And that's the window that you see. See the Supreme Court building right there. That's the website right here. Okay. And this is these are wonderful. You can look up your key terms right here at Legal Information Institute. And these are the fabulous folks who work there and who have, pardon me, that's not true. These are folks who've paid as advertising to be on this page. If you want to look up key terms on Legal Information Institute, this is Cornell's website, you can enter in a case right there, like Roe v. Wade, and it will show you what you need to know. I thought, did I misspeak? Let's see. Help. Welcome to. Legal resources. There's the Constitution and the U.S. Code. That's the federal law right there. Executive orders are listed right there, but the president's executive orders. And you can learn about all kinds of fabulous things right here, like court procedure and constitutional law right there. And let me give you, let's see, state regulations, executive orders, legal resources. Let me see if they're going to tell you here. State law resources, state statutes by topic. Look that up. There's the Supreme Court most recent decisions right there. And all kinds of other sources that you need to be familiar with. Supreme Court rules, glossary of legalese, all kinds of legal terms in alphabetical order are right here for you to take a look at. And it's pretty cool because it explains them quite well. Things that lawyers use routinely, but you might hear the term and be kind of overwhelmed about it. That's a good place to look. And archive of decisions by topic, by author, or by party, right there. They only go back as far as 1990. If your case is older than that, just simply Google the case and information about it will come up. But if you go back to OYA, which is just such a great website, click on cases, and that will give you by term or by name of a case. And right here in search, that's a way small search box up there, but you can look at Roe v. Wade, for example. I'm just using that. It's such a famous case. Click on the name of the case. Y'all can see this, right? You can see how the page is working out, right? You can see that. Here, wait a second. Yeah, there you go. I can see what you can see there. Look here, and it just gives you this really tight, brief facts of the case. In 1971, Jane Roe, a fictional name used in court documents to protect the plaintiff's identity, filed a lawsuit against Henry Wade, the district attorney of Dallas County, where she resided, challenging a Texas law making abortion illegal except by a doctor's orders to save a woman's life. In her lawsuit, Roe alleged that the state laws were unconstitutionally vague and abridged her right of personal privacy protected by the First, the Fourth, Fifth, Ninth, and 14th Amendments to the Constitution. The question for the court was, does the Constitution recognize a woman's right to terminate her pregnancy by abortion? If you scroll down, it will give you the vote on the court. It was a 7-2 decision in her favor, and the majority opinion was written by Harry Blackmun. And they will tell you by seniority or by ideology how the court voted. 7-2, so they show you the 7 justices that were in favor, and the 2 justices, they're kind of shadowed here, okay, or faded out there by ideology or by seniority, how they voted. And it discusses the decision in terms that everyone can readily understand. Inherent in the Due Process Clause of the 14th Amendment is a fundamental right to privacy that protects a pregnant woman's choice whether to have an abortion. However, this right is balanced against the government's interest in protecting women's health and protecting the potentiality of human life. The Texas law challenged in this case violated this right. Justice Harry Blackmun delivered the opinion for the 7-2 majority of the court. First, the court considered whether the case was moot. Now, what is the concept of mootness? What does that mean? If a case is moot, it means that it's no longer an issue. In that case, it would mean that the decision for that individual woman was already settled. Mootness means that the emergency nature of a case, the imminent nature of a case has already been decided. Was the case moot? Well, the court said the case was not moot. When the subject of litigation is capable of repetition yet evading review, a case need not be dismissed as moot. Pregnancy is a classic justification for a conclusion of non-mootness. If she had already delivered a child, would the case be moot? Had she already had an abortion, would the case have been moot? She is capable of being pregnant again. Therefore, that issue is still out there in the ether. That issue is still important. The Due Process Clause of the 14th Amendment protects against state action, the right to privacy, and a woman's right to choose to have an abortion falls within that right of privacy. Now, let me ask you something. I didn't pursue this. Sometimes this stuff is obvious to me, and I forget that y'all may not be on the same page with me. Why are we in federal court about this? Why did this case, did it originate in federal court? No, she sued Dallas District Attorney Henry Wade. And so this case wound its way through the Texas court system, and it wound up at the court because there's a fundamental constitutional right at risk here. She was questioning whether a Texas law, that's your clue, you started in state court, had a constitutional flaw in that law. Constitutional questions are going to wound their way through the state courts. It's not a criminal matter, y'all, it's a civil matter. And you should know the difference between criminal law and civil law. So we're going to back up a moment and talk about that. But why did we go to federal court land here? Because it's a constitutional issue. That's all the Supreme Court's concerned about when it comes to you and me. Now, the Supreme Court gets involved in cases, or you can file your case there, in some unusual circumstances. What might those circumstances be? Well, we're not going to wake up and have a constitutional claim right off the bat. We're going to work our way through the state court system before we get there. But in litigation where the president is concerned, he gets to start at the Supreme Court. So that's why all this stuff about Trump in terms of election law, not the case in Georgia, but Trump saying the election was rigged, which is just ludicrous. That stuff was argued at the Supreme Court. Okay. Questions where the president is involved, like for instance, does the president have to provide a list of phone calls that he got or he made in a particular matter? Yeah, that's going to originate at the Supreme Court. Cases that deal with the president, cases that deal with violations of perhaps federal law with regard to states as a party. New York sues New Jersey to discover what is, who owns the Statue of Liberty. Or Texas sues New Mexico over a dispute about where a boundary is between Texas and New Mexico, or Louisiana and Texas. Those kinds of cases originate at the Supreme Court. Okay? They originate there at the court. The court almost never functions as a trial court except in some extraordinary circumstances. Today, the Supreme Court, thank you. Today, the Supreme Court is not a trial court. It functions as an appellate court. You don't have to close that. Okay, I'm sorry, too loud for you. Sorry about that. So, almost nothing is ever tried at the court. It's an appellate court. That means they don't hear witnesses. That means they read briefs and they hear oral arguments between the plaintiff and the defendant's lawyers. Okay? Questions about that? Comments about that? So what are you supposed to know about these cases? What are you supposed to know about these cases? Whenever you see a case in our little list of cases, in our little worksheet study guide list of cases, whenever you see that, you can simply look up the name of the case right here. And what do I want you to know about the case? I want you to know the facts of the case and the question. And what did the court decide? Right in the first paragraph of the conclusion, it's going to tell you what the court decided. If you want to understand it, though, you're going to have to do a little more reading on that page. Okay? Questions about that? You good about that? Yeah. Okay. It's pretty straightforward in terms of what you should know. All right. So when you're looking at these cases, if you're looking at that worksheet, it's good to know what, let me see if I can find that. I'm going to go back to our class and pull that worksheet up so that you can see it and I can talk to you about it. Okay. Let me go to Canvas. All the signing in. I don't think we need to necessarily share that stuff. So we can stop sharing. Again. Yeah. Yeah, I've written down in my notes on what the Supreme Court had decided based on that case. Yeah, what you want to know is what are the facts of the case? What's the question? What's the court worried about? What are they concerned with? What's the plaintiff need to know in terms of the outcome of that decision? That's what you need to be aware of. Okay, wait a minute. Faculty. Let me scroll down. Get into Canvas so that we can kind of look at that worksheet and talk about some of the problematic things on there for you to be aware of. Here we go. Yeah. I really like that booklet. It's incredibly helpful. So be sure that you look at that Understanding the Federal Courts. I think that this frustrates students a lot, and there's a concept on this study guide that would be good for you to look at. Adversarial proceedings. Adversarial proceedings. What does that refer to? I think this frustrates students because they think that everybody in court is all kind of on the same side, if you will. And that's not the case. The prosecution is there to articulate the state's case. What I'm talking about is these two concepts right here: adversarial proceedings and adversarial system. The prosecution is there to make the state's case that the defendant committed this criminal act. And I want you to be aware of something here. The state could not care less about the victim involved. They are not there to represent the victim. They're upset. They're bringing these charges because their law has been broken. And they want to blame it on the defendant, the person that they've arrested and indicted for violating their law. They're not there to represent the victim or the victim's family. The victim is usually free to sue the defendant. So in that kind of scenario, let's say that I have a terrible car accident and I'm killed. Let's say the person who hit me was drunk and they caused my death, that I died from injuries sustained directly related to the car accident. The state is not going to go after the driver of the other car on behalf of my aggrieved husband. I don't care about that. They're upset that their laws against vehicular manslaughter and driving while intoxicated were violated. That's what they care about. Because they lose their power and authority as a court, as a state, as a political entity, if their laws are not upheld, if the public does not follow the law. After that person is convicted of vehicular manslaughter, driving while intoxicated, my aggrieved husband is able to sue that individual for my wrongful death. So that's a civil issue, not a criminal issue. Okay? Yeah. In the Johnny Depp, Amber Heard issue, nobody's going to jail. That's not what's at stake here. This is a private matter, a civil matter. It damages Johnny Depp as box office, as an actor, as a profitable member of the acting community. Because in our current political atmosphere, domestic violence, beating up somebody, is not celebrated. There was a time in our history that allegations of abuse or violence towards another person might have made him more interesting to the general public. There'll always be paying people who have an appetite for that. But right now, it's a cost-benefit analysis, and Disney says that's not who we want to make an investment and make a film. After they've made a lot of money off of Johnny Depp, suddenly they don't think they can make a lot of money off of Johnny Depp. It is not that they care about Amber Heard. Not at all. All right. That is merely the vehicle for box office poison. If she loses, if she does not prevail, then Disney may want to revisit that contract. Then not because woohoo, Johnny's our friend, it's woohoo, we can make money off of Johnny. That's what that's about. Okay. Go through this list of legal terms, and it's not exhaustive. It's just stuff that you would hear regularly. And when you see a big honking paragraph of something that I've written here, that's what I want you to know about it. Okay, that's what I want you to be aware of. Now, let me ask you this. Gosh, time flies when we're together like this. Let me ask you this. Are there terms, concepts, legal ideas that you're not familiar with, or that you've always wondered and you're not clear about, but you want me to try to answer those questions for you? Now, I'm going to remind you that I'm not a licensed attorney in Texas, and I can't give you any legal advice. And even if I had a law license, I'm not your attorney. So, this is from a purely academic standpoint. So I see here that every judge has a different decision. What do you mean by that? That on the Supreme Court, judges vote. They can write an opinion if they agree or disagree. If they agree with the majority opinion, they can write what's called a concurring opinion. If they are assigned to write the majority opinion, they would be assigned by the Chief Justice to write the majority opinion. They can author that opinion, and then people on the court are free to join that opinion. And if they want to write why they voted the way they did, or maybe they agree, but for different reasons, they can write what's called a concurring opinion. But if they don't agree, they write a dissenting opinion. And people can, by the way, agree with the dissent and write a concurring dissenting opinion. Just to make it that much harder to grasp. Okay. And I say, is civil meaning that a person that is civil meaning that is personal on both sides? Can you elaborate, Mr. Woods, on what you mean by that? Do you mind? Civil means that it's not criminal. When it's something is private, is it civil? That's a very good question. Sometimes, okay. Let me give you an example. Let's say that the state of Texas is really aggravated that its citizens who are consumers of a product like, okay, I'll give you a good example of this, but it's purely fictional. Let's say that the people of Texas have purchased a very popular pickup truck. It's just the pickup truck everybody's got to have. Texas consumers buy lots of them, but there's something faulty in the way that that pickup truck has been constructed, and it explodes on impact in normally survivable accidents, and it burns up and kills everybody in the pickup. The state of Texas can sue the makers of that very popular pickup truck on behalf of the consumers of Texas under Texas Consumer Protection Law, or perhaps the DTPA. Now, people who've lost loved ones in these fiery crashes can sue privately in a civil action for wrongful death against the manufacturer of that automobile. So that's all of this is public because it takes place in court. But when I tell you that something is private, what I'm telling you is that does not involve the state of Texas. So when Johnny Depp sues Amber Heard, it doesn't involve the state in which these alleged allegations occurred. Does that make sense? Okay. All right. Yeah. Okay. Okay, good. I didn't want you to be confused about that. All right. So, other questions or comments that you're concerned with? Facts and evidence are heard and decided upon in which type of court? Either criminal or civil. Facts and evidence are questions that the jury has to answer, and there has to be an evidentiary basis for that jury's decision. So, in the matter where the police officer put his knee, or his weight, I should say, through his knee, through his leg, on the neck of George Foreman in police custody. And we saw a videotape of that because someone stood on the street with a phone and recorded what was happening. By the way, that's the only way you got a conviction in that case, because the videotape revealed to the world, because it was given to a television station and the television station broadcast it, that became evidence of the event. The tape itself is not evidence. It depicted facts and evidence. Does that make sense? So facts and evidence are for a jury to determine. The state is going to argue that the facts illustrate that the police officer killed the victim. Okay. The defense is going to argue that no, the police officer's actions were not the cause of death in George Floyd. In George Floyd's case. That there were other factors that may have caused his death, okay, like his health. When the autopsy was performed, they found a host of other maladies that could have been responsible for his death, that the police officer's actions alone, okay. Yeah, a trial court. Yeah, a court that hears a trial. The Supreme Court is never interested in the guilt or innocence of a defendant. They're interested in the constitutional questions. Was the defendant treated lawfully? Were any of the defendant's rights violated? They don't care about guilt or innocence. That's for a trial court, the trier of fact, to determine. Judges are only interested in whether the applicable law was applied properly. Does that sentence make sense to you? The judge is there to say, yes, that evidence is admissible, that evidence is not. The judge is not on anybody's side. He's simply there to rule on matters of law. The jury is there to understand and support matters of fact. Okay. The trier of fact is the jury. The trier of law is the judge. Okay. So ask those questions. I know y'all don't want your voices on here per se, but I don't care. You can mute yourself if you don't. You can write questions. Type those questions fast. They're on the chat. But anything that you find difficult to grasp, or why did this legal issue work out the way that it did? I'm trying to pick. Go ahead, please.
About the worksheet on capital murder, it says what triggers capital murder in Texas. So specifically asking what triggers capital murder? Like
that's a great question, and don't go further than that sentence. What triggers capital murder? Okay, let's look at capital murder in Texas. I'm going to search for you so that we have a printed list. Capital murder in Texas. And the reason I'm asking you that is because, ta-da, you live here, but it's different in every state. Why? Because state legislatures, oh, wait a minute. I have to put that in a different window, don't I? Okay, hang on. I'm going to highlight this, put this over here, put this up here.
I've written the definition in my notebook. I just want to know what triggers it.
Well, that's a good question. Okay. And because a lot of things can trigger it. Okay. Because it's not an automatic thing. And it's not the same everywhere you live. And circumstances are not always the same. So what triggers it? Okay, let's share.
Isn't it like something that very severe, like a murder, or like
No.
I know it's like punishable by death.
Yes, but a severe murder is not necessarily a capital murder.
I see.
Okay. I could go downstairs right now after class and axe murder my husband. That's not capital murder.
Oh,
if
okay.
I hired someone to axe murder him, it is.
Oh, so basically.
Okay. No. Be very cautious about this.
Oh, sorry.
It's not up to the police to decide if they're going to charge you with capital murder. It's not even up. Well, there is prosecutorial discretion, but in order for something to be capital murder, it has to meet one of the list of things that the legislature has determined is capital murder. So let's look at the statute. Y'all can see this, right? Texas criminal law, capital murder. You can see that.
Mhm.
Okay. What's the law in Texas about capital murder? The offense is described in section 19.03 of the Texas Penal Code. The law was amended in the 86th Texas legislature through Senate Bill 719, effective September 1st, 2019, known as Lauren's Law. The new amendment is added in brackets below to the law as it was before the 2019 legislative session. A person commits an offense if the person commits capital murder. If the person commits an offense, if the person commits murder as defined under section 19.02B1, and here's a list for you. The person murders a police officer or a fireman who is acting in the lawful discharge of an official duty and who the person knows is a peace officer or a fireman. I'll give you an example. When I first moved to Houston, there was a case where a undercover police officer stepped into somebody's front yard in Houston and urinated on their tree in their front yard. Person inside the house saw that, stepped out into the yard and shot that person who was urinating on that tree to death. Killed him, shot him. That person was a police officer. He was undercover, he was plain clothes, and the person who shot the police officer had no idea that it was a police officer. Could that person be charged with capital murder? Not under this statute, he couldn't. Could he have been charged with second-degree murder? Maybe. But it does not mean that he could have automatically been charged with capital murder because he shot a police officer to death. He didn't know it was a police officer. Why would anybody suspect a plainclothes individual urinating on a tree on private property would be a police officer? What in those circumstances would tell you that? Nothing. Did the DA's office charge him with capital murder? No. Okay. The person intentionally commits the murder in the course of committing or attempting to commit, and these are other felonies. So that's a felony murder rule. A person who is attempting to kidnap, burglarize, rob, committing aggravated sexual assault, that means with that they had a weapon at the time, arson, obstruction or retaliation, that means killing a witness or killing a judge or an attorney involved in a case, or making a terroristic threat. Those things are all felonies. And if they commit a murder while committing or attempting to commit any one of those other felonies, that could be a capital murder. Okay. The person commits the murder for remuneration. I like that word. It's hard to say, but it's good. Remuneration. What does that mean? That's murder for hire. So if I axe murder my husband, that's not a capital crime. But if I hire somebody to murder my husband, the person who commits the murder and me are both subject to the death penalty. And usually what happens in that case is the hitman gets caught and testifies against the person who hires them. Okay? Attempted capital murder is not a capital offense. Okay? Attempted murder or murder for hire means that somebody walked into a bar or took an ad out in Craigslist and said, "Hey, I need somebody to kill my husband. I'll pay you." And the people who answer that sort of thing are always police officers, and they, arrest the person for attempted murder for remuneration. The person commits the murder while escaping or attempting to escape from a penal institution. So if somebody breaks out of jail or attempts to break out of jail and somebody dies trying to catch them, or somebody is murdered trying to catch them, that's a capital crime. If a person, and these are all kinds of anticipated circumstances under which that could be applicable. If a person murders an individual under the age of 10, that's a capital crime. Frankly, I think anybody who kills somebody under the age of 18 or over the age of 65 should be subject to capital murder, but the legislature doesn't agree with me. Under the age of 10. If the person murders an individual 10 years of age or older, but younger than 15, or the person murders another person in retaliation for or on account of the service or status of the other person, like a judge, like a justice of the Supreme Court, Court of Criminal Appeals, Court of Appeals, a district court, criminal district court, or a constitutional county court, or statutory county court, a justice court, like a justice of the peace, or a municipal court. So if somebody gets a ticket and the municipal judge says, here's your fine and this is what you're going to pay, and a person murders that judge in retaliation for that, that's a capital crime. Okay? So notice that those things are really limited, really specific. And in other states, state legislatures have a different list of what constitutes a capital crime. And it's up to the state legislature to determine what is going to be a capital crime. So, like, it used to be if you murdered more than one person in a criminal event, that was a capital crime. But see, that's not part of the statute. So you have to know this so that you understand why something's a capital crime and why it's not. Why the difference? Because the state legislature says so. So, I mean, it could be awful. It could be a terrible crime. But if it doesn't fit those parameters, we don't get to just make up as we go what constitutes a capital crime. It has to be codified. And I'll tell you why. There was a Supreme Court case called Furman versus Georgia. And in Furman versus Georgia, the Supreme Court said that the death penalty cannot be arbitrary or capricious, that they can't make it up as they go. They have to know in advance what's going to what constitutes a capital crime. Okay. Questions about that? Keep working your way through these sheets. When we get together on Tuesday, next week is the last week that we have together. So when we get together on Tuesday, I want you to be aware of the structure of the federal court system, and I want you to have at least worked your way through this sheet so that if there are any holes in it that you don't understand, or just like what we went through, why in the world is something a capital crime? Because the legislature says it is. Okay. And out in California, it's different than it is here. In New York, it's different than it is here. So we can talk more about this death penalty stuff too. It's rare, it's unusual, it doesn't happen very often. And even if it does, here's something else. Don't assume that somebody's automatically going to be sentenced to death, because those kinds of trials are very expensive. And those appeals, there's an automatic appeal for a capital crime. And those things are expensive and they cost a lot of money. So the state doesn't want to pay for that. And so district attorneys are encouraged to use their prosecutorial discretion not to pursue capital charges. So just because somebody does one of these awful things, don't assume right off that that's a capital crime or that somebody's automatically going to be sentenced to death. Okay? Questions? Let's quit, and I will see y'all Tuesday at 2 o'clock, and we'll be winding down. So questions that you might have. And by the way, it's just been a really tough semester for people to get through the exams and COVID and all that kind of stuff. So I really appreciate what y'all have had to go through with the semester and that kind of thing. So I want to open all the exams for y'all to, if you need to retake an exam or you need to deal with that, or if you've taken it 3 times, that's your score. That's what you get. But if you have missed a test, those tests are going to be open throughout the week of finals for everybody to be able to take that. And remember that your final exam is not comprehensive. Okay? Questions? Comments? All right. I'll see you guys Tuesday. Okay? All right. Talk to y'all later.